Hi, everybody. This is Steve Maggi from SMA Law Firm. I'm going to talk today about the new presidential proclamation or executive order, which went into effect yesterday, June 24th, 2020, and talk about its effects, what exactly it enumerates, what it entails, who is affected, and then to come up with some alternative strategies and give you some information so you know exactly where you stand. If you are a foreign national who's been sponsored, if you're a US company sponsoring a foreign national, if you're a multinational or an entrepreneur that is planning on launching operations in the US, this may affect you. And so I wanted to talk about that today. First of all, what is enumerated in this proclamation? Well, there are four specific categories that are mentioned that are non-immigrant or temporary visas. And what it says in effect is that individuals who do not hold those visas now, as of the 24th of June, will not be allowed to enter with those visas. So if they receive those visas subsequent to the 24th of June and before the 31st of December of this year, they will not be allowed to enter under those specific visas. So we don't know right now when the embassies and consulates will start processing again. Right now, interviews are on hold as of March 13th. We're waiting for the Department of State to announce when that will happen. So in effect, right now, this doesn't have any specific effect until people are actually able to attend their consular interviews. So the rule of thumb, and I'll say this various times, is for anyone who's physically in the US to remain in the US to change or extend their status, and for employers to make sure that they're maintaining their employees in status by keeping them on payroll. And if they're going to bring employees over on alternative visas, then they're in the United States and they should do a change of status and not consular processing. So let's talk about the specific visas that are enumerated. The H-1B visa is the specialized knowledge visa. It's for highly trained individuals who have degrees in some technical field. Usually it's a STEM field, and they're highly sought after. Most of them are in the United States right now, and they've received F1 visas and what's called optional practical training. So they're usually here, and so what's important for employers to know is that they should not designate their petitions as consular processing. Anytime you do that now, given this proclamation, you're risking that that individual will not be able to return to the US under these visa categories until next year. So when in doubt, stay home, which means stay in the US and make sure that the status of those individuals is being kept intact. The H-2B visa is the non-agricultural seasonal worker visa. So the amusement parks and ski resorts that we have in the US generally use those visas. Then you have the J visa, which is the cultural exchange visa, which is used by upwards to 300,000 people per year. And that includes a lot of interns and trainees. It's an opportunity for people with degrees to get practical training that they can't get necessarily in their home country through a J1 sponsor organization. So that's a big hit on the economy here in terms of temporary labor. And then we have the L visa, which is one of the visas that our firm specializes in, which is for what's called an intercompany transfer. Essentially, that's for managers, executives, and individuals with what's called specialized knowledge that work for overseas affiliates, parent companies, or subsidiaries, and they've done so for at least 1 year. So essentially, companies that are setting up subsidiaries in the US will transfer some of their employees, usually the very high level ones, to expand their businesses. This is used by big multinational companies, but it's important to keep in mind that it's also used by a lot of companies that have recently opened businesses in the US, and they're bringing over individuals who have a very strict and special knowledge that's unique to that company that allows them to build out a business, to implement a business plan, and to create a lot of American jobs. It's important to reiterate that anyone right now with a current visa is allowed to enter the United States. So this affects people who might be applying for these specific 4 visa categories for the next 6 months, but it doesn't impact the ones who already have visas. So that means that anyone can enter the US on a current visa as long as they comply with the travel restrictions that are in place. Those restrictions say that if you are residing in a Schengen area country, which is any of the 28 members of the Schengen area in Europe, the UK or Ireland, China, Iran, or Brazil, that you must be quarantined for 14 days in a third country before you enter the United States. If you're residing currently in any country that I didn't mention, then you can come to the US directly on any current visa that you have, as long as it's an active visa. Or if you're a person from one of the 39 countries that's part of the visa waiver program through the ESTA program. So important to keep that in mind. This is not restricting entry for the majority of people who already have visas. Anyone with a visa now can still enter the US. What are some alternatives to these visas for employers that are worried about not being able to bring in the specific people that they were sponsoring or planning on sponsoring? One of them is, for example, the J1 is the H3. It's called the Practical Training Visa. It allows employers to directly sponsor individuals who are from other countries, as long as they can prove that that training or something similar would not be available in that person's home country. And it obviates the need for a J1 sponsor organization. Those petitions are made directly with Immigration Service in the US. For L visas, our alternative visa is always the E2, but that's only in cases where the nationality of the individual to be sponsored matches that of the parent company or the company that owns the majority of the US entity. So for example, a Danish individual could be sponsored under E2 if the US company that's set up here is at least 50% Danish owned, and that's by a specific company and or individual investors. So E2 is always the best option. In many cases, depending on the country of origin, you can get a 5-year visa as opposed to a 1 or 3-year visa under the L1. And so that's a very good alternative. Also, if the individuals are well known in their field, they're well recognized, they might qualify for an O1 extraordinary ability visa, and that's irrespective of what their profession is. They can be hired for any position in the United States as long as you can prove that they have a certain level of recognition. And usually that requires proof that they've had articles published about them in major media or what's called major trade. So that O1 is a great alternative. With H1B, it's important to keep in mind that most of the individuals that are being sponsored this year, there are 85,000 cases that were selected. The majority of the individuals being sponsored are currently in the United States. They're on what's called optional practical training as part of a student visa. If that is the case, the rule of thumb is to make sure that you apply as a change of status. That allows them to extend their OPT status and stay legally in the US until you get a final answer on your case, and then on October 1st, they automatically will change to H-1B status. This obviates the need for them to leave the United States. What this means is that if you have anyone in the US who could qualify under these categories, the best thing to do is to apply for them as a change of status if they're in another status, or to use one of these alternative visas in order to do so. If you have any other questions related to the proclamation or any immigration related questions, please feel free to leave a message below or email me at smaggi@smalawyers.com. Thank you.